Welcome to Frank Bruno Law. Nice to be here. I've said this before and I'll say it again. This is the best part of my day. 34. Common estate planning traps and how to avoid them. Here we go. I'll give you some good information. So we're up to the next section where people don't take into account their own mortality and their own potential incapacity. So number 18 of the 34 common traps is not having a living will and a medical power of attorney. A living will, and I'll use the term healthcare proxy. That's what is most frequently used in New York. So a comprehensive estate plan may include a will, it's a last will and testament, and a trust. These are documents that will take your wealth, your legacy, and pass it on to the next generation. A properly or a well-designed trust can afford you, we can take into account incapacity during your life, and it's quite a robust document. In conjunction with that, it makes sense to have a living will, right? So living will, healthcare proxy, healthcare directive, medical power of attorney, those items, this is in the category of advanced directives, right? So the living will really concerns itself with end-of-life decisions. So it's living because you're alive when it takes place, and the will portion is really where you're contemplating or anticipating an end-of-life scenario. So this is where you would direct, while you're healthy and well and competent and have capacity, you say to a family member, to prevent them angst and anxiety later on in your life, where you say, if it should be, hey, please try and save me, save my life, make me healthy and well. But if there comes a time where the doctor says to you that I am only being kept alive by machines, well, if that's the case, and then he speaks with a colleague and she confirms that I'm not able to be resuscitated and you're only keeping my heart beating through mechanical means, you're only feeding me through a tube, right? This type of thing. Well, I'm telling you in advance, give me pain medicine, but please remove me. Okay. So that's really what that document is. And the healthcare proxy, this will allow someone to step into your shoes and be your voice to have a dialogue with your doctor about the care that you may need. It doesn't always concern end-of-life decisions, right? The healthcare proxy, you could be a person that was hit by a bus and now you're in a coma, or you're temporarily incapacitated or not able to speak. That's when the healthcare proxy can take effect. So I'll give a little bit more at a later point about these documents, but in the context of my 34 common estate planning traps and how to avoid them, it would be not having a healthcare proxy and a living will. Thank you very much.